Okay, Dennis, what do you say? Should we get started?
Sure, let's go for it.
Okay. So good afternoon, everybody who is on the call. I know varying times for each of you, as we're seeing on the chat, we've got New York, we've got some West Coast people, but so thank you for blocking out an hour in the middle of your day, regardless of where you are. So today we do intend to give you guys a good overview of physician contracts. Fairly high level, but things that you will likely see, things you might see, things you should look out for, some negotiation tips and strategies, but feel free to add questions to the chat as we go through. Dennis and I will do our best to address some of those if we can, but we also have some time at the end for Q&A. So with that, let's get going. Hide this little box here. Okay, I'm gonna let Dennis introduce himself first. He is our guest speaker joining us today and subject matter expert, if you will. I've had the pleasure of working with Dennis for a while, particularly when he was in-house counsel here at Providence. And just a warning, Dennis does have a reputation for being a fun attorney. So I hope you guys enjoy him as much as I do. So go ahead, Dennis, with your background.
Hey. Thanks, Christy, and
Sure.
good, I guess it's afternoon, everybody. So my name's Dennis Westlind. I am the managing partner at a little law firm here in Portland, Oregon called Bullard Law. We are a labor and employment boutique firm. We primarily represent employers, but we also represent the occasional professional like physicians. And that's a part of my practice. Before I was at Bullard Law, I was with Providence Health and Services for 7 years, where I was the primary lawyer in charge of all of their physician agreements. So I've learned a thing or two about how at least one health system contracts with its providers and maybe a couple others. So in general, I've been practicing law for about 20 years, most of it for healthcare organizations. So happy to be here today.
Awesome. Thanks, Dennis. Yeah, just quickly about myself. I'm Christy. I oversee our GME outreach program here within PS&D and our recruitment teams. I, personally have recruited lots and lots of physicians into their jobs, many of them their first jobs, worked really closely with a lot of our residents and helped them navigate kind of the job search. So I just have a real passion for this and I'm excited to be here with you guys. So thanks for having the both of us. So about PS&D, you can read the slide. I'll also tell you Provider Solutions and Development, where we are a group essentially born and raised within the Providence Health System out here on the West Coast. We've been providing physician recruitment services to Providence for years and years, as well as their affiliates. But we also started supporting recruitment efforts for several other health systems across the country about 5 years ago, fairly organic process, but just basically wanted to spread our process and style to other health systems in need. So I think as a team, we just really value that relationship between the physician, you all, and the recruiter, and really believe wholeheartedly in helping you guys find not just a position, but the right position for you all. So that's kind of the mission of PS&D. And then a little bit more about sort of our GME outreach team. There's a small subset of us. It's a newer team, but we do solely exist to support residents and fellows during training. So, we aim to supply you with knowledge about compensation, contracts, obviously today, job search timelines, financial success, both while you're in training as well as when you get out. Basically all the business things that you guys are not probably taught while you're in your training program. Late last week, I had a chat with a rheumatology fellow who may or may not be joining us today, who he needed to negotiate his contract prior to our chat. So we jumped on one-on-one last week and he asked me the question, so why do you guys even do this? What's in this for you? And I thought it was a good question, so I wanted to address it with you all in case you were wondering the same thing. And truthfully, there's not a lot in it for us. Our mission of the outreach team is, oh yeah, there you are. Hi, Dr. Anderson. The mission of our outreach team is really just to connect and empower you guys with information that you don't have. Don't get me wrong. Like I told Dr. Anderson, if he ever wanted to come out west and work for Providence or any of the health systems that we recruit for, that we would love to talk with you, but no pressure. We just really want to engage with you and share information that we have, because we know that a lot of you are not getting it in your training programs. So no, we don't charge for this. We just want you to find this information beneficial, and that we hope that we set you up for success as you venture into the world of finding your first job, which we know can be very daunting. So that's why we exist. We come at you with quite a bit of experience and hope that today is valuable for you. So thanks for moving me on, Aaron. Here's the agenda for today. Basic anatomy of a contract. We used the anatomy term in our last compensation one, so a little carryover there. We'll go through that. We'll talk about a couple topics that are a little bit more in detail. We'll talk about reviewing and negotiating offers, and we'll leave some time for Q&A at the end. All right. 6 key elements. 6 key elements. These are the 6 things, obviously contracts have many, many different clauses and pieces to them, but these are 6 things you will likely come across. So, and things to consider. So the term of your contract, your initial term, compensation structures and how they may evolve over time, malpractice, any prerequisites you may need to have before you start your employment, behavioral standards. I don't have a lot to offer, but Dennis will. And then what happens at the end of your employment. So those are the kind of the 6 things we'll start with here. Again, as we go, please feel free to contribute in the chat, but hopefully we'll cover these in some decent detail. So contract term. Okay, Dennis, length of contract. Can you help kind of walk us through what this means, kind of what typical term lengths are, and how they may impact folks that are signing their first contract?
Sure thing, Christy.
Cool.
So every contract has a term in it. The term is, how long is this contract good for? Is this a 1-year contract, a 5-year contract? I've even seen 10-year physician agreements. So you want to look and see, what am I getting myself into? Is this a short-term arrangement, medium, or long-term arrangement? And depending on which one of those it is, what happens when we reach the end of that term? Does it automatically renew, or might I be, do the parties intend this to be a truly 2-year agreement and then we part ways and move on? Or is this really the first 2 years of what everybody hopes to be a longer relationship?
And so other terms, we've seen the term evergreen. That simply just means same contract over and over again.
Exactly.
Renew it. Okay.
And if either party gives notice to the other that says, hey, this has been great, but I want to move on, it will automatically renew for usually a term of 1 more year.
Okay.
So there's an anniversary date in the contract, and you have a window of time before that anniversary date to give your farewells. And if you don't, then it will automatically renew for another year.
Okay.
And those can then automatically renew theoretically for forever.
Okay. Yeah, good to know. We're going to jump from there into comp, because term of contract has obviously some implications on compensation. So it's a good segue from there. So what happens to your compensation after your term is up? I think we have become familiar, and I know within the Providence system, with guaranteeing a compensation package for a certain amount of time, especially sort of a base salary. So what does that mean for your compensation, your term? You have any advice as far as that goes?
Sure. When you're considering entering into a contract, obviously you want to know how much you will be paid. And what we're seeing for physicians and providers more and more is moving from a salary guarantee into a pay for performance or pay for productivity model, where you're paid based on how many patients you see or how many procedures you perform or whatever metric the employer wants. What we often see, though, is a hybrid where there is a salary that is guaranteed during the initial term of the contract. In other words, you don't want to go into a new situation, say move halfway across or all the way across the country, only to find out like, oh, it's all purely based on productivity and yeah, there's no patients here. Nobody wants that. So they'll often put in a salary guarantee that says you'll make X dollars per year for the first 2 years, but then you're purely on productivity and then you're on your own. And the idea there is that you can build up a practice in those first 2 years, and then hopefully the productivity will be more than you would have made on a salary alone. And oftentimes the salary is simply a floor or a minimum, and then you can exceed that through your productivity.
Okay. Yeah. And that's pretty common with what we see too. And I'm curious, well, actually, I'm just going to offer up for those of you guys who are on the call to be cognizant of that. You know, your first contract is likely not going to spell out what happens for you after your first contract. So make sure you're asking those questions, right? So asking your future employer how many people in your practice actually achieve that salary draw or exceed it. You know, how does the practice help you ramp up and advertise or, you know, kind of get your name out in the community? So make sure that you guys have a tight understanding of what that looks like. You know, I think it's probably safe to assume that they want, if you're going to move to productivity, they'd like to see you produce. And so hopefully we'll be supplying you with data to show, you know, kind of where you're at before they roll you off of that plan. But just make sure that you're asking those questions because it likely will not be spelled out in your first contract. So good to arm yourself with that knowledge before signing on the dotted line. So one other question here, Dennis, and this is off the cuff, but, you know, sometimes we see incentives that are linked to longer term lengths than your contract. So for example, let's say you get a pretty large sign-on bonus and it's tied to, you know, a 4-year payback period, but your initial contract's only 2 years. Can you talk about that a little bit? Are those sort of separate? One's your main contract and one's like a clause, or how does that work?
What I frequently see is you have your employment agreement on the one hand, and then a separate agreement, or perhaps an addendum to that employment agreement, which is just sort of like, you know, something stapled on that specifically addresses those incentives. So what you might have is an employment agreement for an initial 2-year term, but then some sort of bonus agreement. And, you know, you look at it and you go, oh, they're going to pay me a big boatload of money to move out to Timbuktu. That's great. I'll take that. And I'll spend my 2 years and then I'll bail, because who wants to live in Timbuktu? But then if you look at that bonus agreement, if I drafted it, it would say something like, if you want to, you know, you'll get that bonus, but if you leave Timbuktu before X number of years, then you have to repay either all or some percentage of that bonus. We're paying you this so that you will stay, not to get you out here initially. So you need to look at both of those in conjunction, because sometimes the payback period might actually be longer than your contract. And then what happens is, if you finish your 2 years on your contract and then you jump ship, you still may owe the repayment of all or part of that bonus that you received. So it's an additional incentive that your employer will put in there to get you to stay and renew and negotiate a continuation of your contract, or simply let it roll over.
Perfect. Okay.
So just because your contract's over doesn't mean your obligation is over.
There we go. Okay. Yeah. And I think we'll dive into this a little bit more later on, but that's good to know. Okay. Next piece, malpractice, which everybody is always curious about. Both types of malpractice coverage, as well as tail, which people, that was a question from our last one of these that we hosted, was the question, some questions around tail. So hoping you could help us understand malpractice a little bit more, maybe in a little bit more detail, than make sure that you have it. What should people be looking for? And is that something that your employer should provide, et cetera?
Sure thing.
Yeah.
So that last question is the easiest to answer. Yeah, your employer should be providing this. And it's one of the terms you want to look for in that employment agreement is, am I going to be covered, or is this something else that I need to worry about on my own? Now, there might be smaller clinics, smaller employers out there that for whatever reason don't do this, but they are now the exception, not the rule. And, you know, organizations get better rates than individuals. So it just makes sense for everybody, for the organization to be supplying the malpractice coverage. Most malpractice coverage is done on what we call a claims made basis. So if I have malpractice coverage that, say, lasts from January 1st of 2021 through December 31st of 2022, then it will cover any claims that are made in that 2-year period. But the statute of limitations to file a lawsuit is pretty long. Depending on what state you're in, it's 2, 3, 4 years. So to provide coverage after the actual period of coverage, we have something called tail coverage or tail insurance. And if you imagine like a dog, the body of the dog is the time of your actual employment, and the tail is after your employment. You can still get sued, but you're not employed any longer. So tail coverage is special coverage that applies to any lawsuits that are made after you leave employment. Now, there's actually something related to tail coverage called, I love this term, nose coverage. So let's say I leave my employer and oops, I failed to get tail coverage. You can actually buy something called nose coverage that will cover you for claims that have not yet been made. Nobody's going to insure those, but for my practice before the time I buy the insurance. So if you ever leave an employer and you're not able to secure tail coverage for whatever reason, you can go to your subsequent employer and say, hey, I want you guys to provide nose coverage. But when you're looking over your contract, tail coverage is the most common and the most important. So you want to see, is this something that the employer will provide when I leave my employment?
Good to know. I was thinking about when we hire people onto, into our organization, and they had been practicing prior and they have to pay off their tail. A common question is, will you guys pay my tail? And I think valid question. I mean, tail can be fairly expensive depending on your specialty, but the answer is no. I mean, our ability to sort of pay off your, directly pay off your tail is, I don't know if there's a legal thing there, Dennis, but we definitely don't engage in that. But the conversation we typically have is you'll likely need to just, attribute your sign-on bonus to paying that off, or however you want to come up with the funds. But asking for your new employer to pay your former tail doesn't typically work. Is that your experience as well?
That's been my experience as well. And what we'll usually say in response is like, no, we're not going to do that, but we'll talk about a sign-on bonus.
Yeah.
And again, we like the sign-on bonus better because we can structure in there a repayment obligation should you not complete the term of your employment or stay as long as we had hoped. Whereas if we're just giving money to some insurance company, we're never going to see it again. So it allows the employer a bit more control.
Okay. I don't know if there are any questions. I don't see any in the chat about tail, but it's usually a hot topic, and malpractice in general. And then just one other thing I was thinking of, if any of you on the call are thinking about doing contract work, like 1099 contracts, you'll likely have to supply your own malpractice coverage. That being said, if you're going to join a locums company and do locums work for a couple of years, typically your malpractice insurance is covered via the locums agency that you'll be employed by for that period of time. So there's a little bit of a difference there. Just depends on how you're engaging with your locums work or your contract work. So, okay.
We got a question.
Here we go. Do residents need tail insurance for after graduate residency before you start working? That's an interesting question. I assume you have coverage as a resident currently. I should pull up a resident contract, but my assumption would be as part of the organization that you're training with that you would have malpractice coverage.
I would hope so. And I would ask them, I would direct that question to them and say, hey, am I covered once I leave my residency?
Yeah.
In other words, do you provide tail coverage?
Right.
Because if you can be sued, you want that to be covered.
Yeah.
And yeah, you can totally get sued for something you did in your graduate residency. So something to look into.
Yeah, my assumption is you probably do have tail coverage through your training program right now. But yeah. Good question.
Worth double checking.
Yeah, absolutely. All right, let's jump forward to prerequisites for employment. So Dennis, just, quickly, we could run through some of the various prerequisites that employers are looking for. Yeah, go ahead.
Yeah, and when you open up your employment agreement, what will likely be in there are some things the employer wants you to complete before it will allow you to practice, or it will allow you to come on board and be an employee. And these are four of the most common. State licensure, obviously, states seem to want people to be licensed to practice medicine. Still not sure why, but that seems to be a trend. Kidding. If you're going to be in a specialty practice, your hospital is going to want to see the board certification. You're going to want to have admitting privileges to their hospital or to a local hospital. And then last but not least, drug screen. And this used to be like such the non-issue until about, I don't know, 10 years ago when like Washington and Colorado thought like, man, legalizing pot's a really great idea. And then a whole bunch of medical students and residents thought, wow, smoking dope's a really great idea. And then, all these great ideas until they went and they took a drug test and failed and found out that their offers were being revoked because they didn't pass a drug screen. Wow. So be super aware. Yeah, most employers are going to be doing a drug screen. And yeah, they will yank your offer if you fail your drug screen. I've seen that happen. Good news is, you're all physicians. You can read the reports and figure out how long you need not to have had one of those tasty brownies before you go out and take your drug screen. So use your heads.
Yeah, absolutely. Yeah.
And there's another question from Fernanda. If you're considering an independent contract model, can you ask them to pay for the malpractice insurance? You could ask, but they're more likely than not going to want to see that built into whatever they are paying you. And not to bore you with the reasons, but if you're going to be an independent contractor, the party with whom you're contracting really wants to make sure that you are not an employee. And one of the ways that they can ensure that you're not an employee is by making insurance totally your problem. So if they're getting good legal advice, they will run screaming from anybody wanting to ask them to pay for their malpractice insurance and instead say, well, yeah, here's a couple extra bucks, go get your own, but not really take on the burden of, reimbursing for a bill or something like that. It just starts to look like employment.
Yep. Another.
Sorry, I need to stop.
What did you say, Dennis? Back to some of the prerequisites, just throwing out from my experience to be super mindful of how long some of these prerequisites take. State licensure can be a real bear. California can take you 9 months to a year. And a lot of this stuff has a domino effect. Hospital privileges are contingent upon, boards or state licensure. So make sure that you have your ducks in a row. You know, as a warning, when you sign your contract, you're going to be inundated with requests for paperwork. And they're all necessary to complete and necessary to complete in a timely manner at that. So just make sure you're paying close attention. You guys are going to have a lot on your mind. You're busy as is, but those requests for completion of paperwork are super important. So just be aware of that. They will be coming your way. So that's my 2 cents on prerequisites. But
and I hear now that with COVID, everything has slowed down that much more. So
yeah, it's actually interesting. We have eliminated some pieces that we used to do up front just to kind of speed up to get people up, but it just kind of goes back and forth. And so I think the rule of thumb though is if it's being requested, you're going to have to do it, and it's going to feel like a lot, right? And state licensure and board cert are not 2 things that are going to go away as far as requests. So yeah, nope. Probably not drug screens either. Okay, behavioral standards. Again, I don't have a lot to contribute here, but perhaps you have a few things, Dennis, that you just want to call out that people should be looking for in contracts.
Yeah, sure thing. So if we went back in time 20 years ago, this slide wouldn't be here. Things have changed, you know, and this is sort of here not only because of what we term the Me Too movement, but everything that led up to that. I have found that health providers and systems are far less forgiving of bad provider behavior today than they were in years past. And hopefully that does not come as a surprise to anybody, but because it still comes as a surprise to enough people, that's why this is here. Most of our provider agreements are going to have something in there that says, you need to abide by all of the hospital's policies, our code of conduct, our code of ethics, our employee handbook, all of that kind of stuff. I urge you, take that seriously, read that stuff, because there's things in there that might not be totally intuitive. Hopefully, a lot of the really major stuff is totally intuitive. You know, if let's face it, if, you know, a few years back, you were thinking like, what should I do with my life? You watched a few episodes of House and you were like, I want to be that guy. This is for you. Okay. But there's other stuff in there that might, and I'll give you a for example. There might be something in your agreement that says if certain things occur to you completely outside of your employment, you have an obligation to tell your employer. Things like being arrested, being convicted, and it happens. And you need to be aware of that because you could put your job, and more importantly, you could be putting your health system in jeopardy if you don't comply with those things. So I urge you, take it super seriously. These are being enforced. And just familiarize yourself with the things that they're asking you to obey and follow. It'll be worth the 10 minutes it takes.
I think you said once, if it's referenced in your contract, read it.
Yep. Good advice.
Yeah.
Not just because I gave it. It's just good advice.
Very sound, very smart man. Okay, so end of employment. This is the last of our, I think, six pieces here, but pretty important part. So can you talk to us about the end of employment? I think I would assume there's some typical ways that employment ends, but it's probably good to talk through what that means. And then we'll talk to about in a later slide about how that might impact some of the incentives that you did or didn't receive upon signing. So anyway, if you wouldn't mind talking about, you know, for cause and no terms and that kind of thing.
Absolutely. So it's funny, whenever we enter into a new employment agreement, most of us are thinking like, oh, wow, I'm going to work here forever. So we look and go like, how much am I being paid? How big of an office do I get? Do I get a company car? And is it a Kia or a Mercedes? You know, that's what we're all excited about. And then we see like, yeah, there's some stuff about how this could end, but I'm not going to read that because I'm going to be here forever. And then 2 years later, we're thinking, man, I want out. So it's a good idea to come back and say like, okay, I know I'm in love, but this is our prenup. So I want to know if things go sour, how are we going to break up in an amicable way? And your employment agreement is going to have a couple clauses in there that spell out how that will work. Leah, I'm going to get back to your question in a little bit, so don't forget. So basically, there's a couple different ways that your employment can end. One is the parties just decide not to renew the agreement and go their separate ways at the end. That's actually not the most common way to end an agreement. The most common ways are what we call a no-cause termination. Most of our employment agreements will say that one party or the other can say so long, see you, good luck, at any point during this relationship, as long as they give an appropriate amount of notice to the other. Now, that means you could say, I'm tired of Timbuktu. I want to go back to New York where there's like, you know, a deli. Great, good for you. Read your employment agreement because it's very likely going to say you need to give a certain amount of notice before you can do that. And the typical notice periods that we see vary from 90 days, 120 days, all the way up to 180. Now, why are those there? Well, your employer probably hired you because they need you. They need somebody with your skill set. And if you leave, they're going to want to replace you with somebody with your skill set, which may be really hard to go out and recruit. So I'll give you for example, I just advised a physician recently who needed to leave the city where she was employed by a health system to go and take care of her elderly parents. And this is in the time of COVID. They were both in their 80s. They couldn't go out. They couldn't shop for themselves. It was really, really difficult. So she wanted out. She had a 120-day notice provision though. And her employer was threatening to sue her for the cost of going out and hiring locums replacement to cover that time period of her notice. So luckily we were able to negotiate a separation so nobody had to sue anybody and she got to go take care of her parents and everybody was happy. But if you just act rashly and don't think that through, you can get yourself in trouble. Now, there's also in the agreement very likely going to be something for cause termination. And what that means is one party or the other has violated some of their obligations under the employment agreement. Most often, this is used when the employer wants to send a physician on their way very quickly and not hang around because they've done something really, really bad. So again, that usually ties into those behavioral standards that I just mentioned. So this is where if somebody, you know, engages in unlawful harassment or discrimination, or, you know, ends up on the front page of the paper because they got arrested doing something really stupid. Yeah, that's when for cause is usually triggered. Mm-hmm. More often than not, both parties want this to be a no cause termination. And sometimes, usually, the no cause termination provision say, you know, we can give you 90 days notice and let you work the 90 days, or we can just give you 90 days pay and say, see you later. So just be aware of those notice periods. It's a trap for the unwary. Christy, any more on that? If not, I have a question.
Do you want to take Leah's question now or?
Yeah.
Okay.
So and Leah, I assume this refers to the behavioral standards we just talked about. You ask, are some things enforceable, like social media bans or a ban on the ability to express opinion or join organizations or unions or stuff like that? There are laws in place, notably the National Labor Relations Act, that does give all employees, who are not supervisors though, but everybody else, the ability to engage in what we call protected concerted activity, like getting together with their coworkers to protest a working condition, or to advocate for better pay and benefits, or join a union, or to express those opinions out on social media. So I don't see those written into contracts, certainly not contracts I'm involved in, because I'll scratch that stuff out real quick. But if it were in there, that would probably not be enforceable. Now, there are occasions where by contract, you can restrict somebody's ability to express an opinion. And that is when, let's say you have an employer that really wants to make sure that anybody who is claiming to speak on behalf of the employer actually has the authority to do so. You know, like, I go to work for XYZ health system, and I'm out on Facebook saying, you know, XYZ health system thinks that Ted Cruz should be made emperor of the universe. You know, nobody really wants their employees doing that kind of stuff and speaking for the organization. So they can totally tell you, no, you don't get to speak on behalf of the organization without the authorization and consent to do so. The other place where it can come into play is if you're working for a health system. This comes up in the Catholic health system world, where the system is requiring that you abide by, say, certain health directives that comply with their Catholic sponsorship or their mission. They don't necessarily want you going out with your, you know, employee badge on, going to work for Planned Parenthood. Now, they're probably not going to stop you from volunteering at Planned Parenthood, but they may limit how you can connect that to your employment. So hopefully that helps.
Good.
Saad, your question about salaries is coming up later. So if you don't mind, I'm going to skip that. And then if I don't answer it in a little bit, I want you to like raise your hand or, you know, yell at me.
Yeah, we intend to get to that toward the end of this one. So thanks for that. So a couple more kind of, we are calling it beyond the basics, which those first 6 were, but talking about these incentives, as well as restrictive covenants. Also, people think of, or more commonly said, non-competes, which I think is just a piece of a restrictive covenant. Something I've learned from you recently, Dennis. So let's talk about these incentives. We've touched on this already a couple of times, so we might not need to spend a lot of time on it, but Aaron, next slide for this one. Basically, kind of back to the end of the employment, what happens with these incentives that you may or may not have received. You know, typically these are loan repayment, sign-on bonuses, you know, often relocation expenses are tied to a service obligation. So just curious if you have any additional things to offer by way of what to look for when you're signing your contract and you have these incentives looped in.
I think we've pretty much covered this. You know, I would throw out there, and Saad, I hope I'm pronouncing that. This kind of ties into your next question about are salaries negotiable? One of the things that you can do to negotiate your contract is to think about what types of things would I be willing to make a longer term commitment in exchange for, like relocation or repayment of student loans? Because I find that those things might often be more readily negotiated than simply straight salary. But we'll come back to that in a little bit. But just a reminder, make sure you read those carefully because it's not free money.
Right. Yeah. And I think, you know, general rule of thumb for you guys is that, you know, the larger chunk of money that you're being offered, the longer the service obligation likely is on the back end. And then the other thing to kind of think about is the payback period that's associated with this incentive that you're receiving. So, you know, make sure that you understand that, and the way that we structure typically ours is that it's prorated. So if you know, in your fifth year, you might be free and clear. In your fourth year, you might owe 25% of what you were given, that kind of thing. So make sure that you understand that if you choose to leave after 3 years into a 5-year payback period, that you hopefully will only owe a percentage back, and maybe it still makes sense for you to receive those funds, right? But maybe it's written that you're going to owe it all back until the very end of that. So just make sure that you're kind of reading carefully on the payback schedules that they put in place with your incentives. But I think we've talked about this a lot, but they definitely go hand in hand. So
and another, Christy, another tip I would throw out there would be, as you're negotiating your next agreement, and somebody says, hey, I know you're at Timbuktu and you seem really happy there, but come to our system, come to our clinic. You can go to them and say, man, I would love to, but I've got 2 years of a repayment obligation left to go.
Yeah.
And that place might say, oh, well, we're willing to pick that tab up.
Yep.
So it's it's not going to help you much on your first gig, but on your second gig, that's a good negotiation point.
Good point. Yep. We do see that. Okay. And then let's talk about restrictive covenants, non-competes, non-solicitation agreements, our favorite topic. And then, I think it's always on everybody's mind is, do these things hold up in court, right? Well, look at that animation there. So curious if you can walk us through some of the pieces of this and, what they typically look like. So yeah, go ahead.
So I'm sure you all know this, but just in case, a non-compete or a non-competition agreement is an agreement that says, at the end of my employment, I will not go to one of your competitors and work for them for some period of time. So if I go to work for ABC Health System in Timbuktu, I might not be able to go to work for XYZ Health System, also in Timbuktu, if they are competing. And there's as many non-competes out there as there are employment agreements. They are infinitely adjustable and tailorable, if that's a word, to individual situations. So sometimes a non-compete will say, hey, if you come to work for us, you can't practice medicine in our community for the 2 years after you leave. Maybe because you're a GP and they just don't want you at all. Others might say, oh, if you're a brain transplant specialist, you can't transplant brains in our community for another 2 years, which means great. You can go out and you can do brain surgery. You just can't transplant them. So they're less restrictive. The question is, though, do they hold up in court? Answer, yeah, sometimes. Every state has different standards that they apply in the court system to determine whether non-competes are going to be upheld. And what's interesting in the medical field, as opposed to other fields, is that courts don't want to say, we're not going to let physicians practice, because if we did, that could have an impact on our community and deprive people of potentially life-saving healthcare that they otherwise wouldn't get. So courts hold health systems and health employers to really high standards. So they will typically not say, hey, if you come to work for ABC Health System in Timbuktu, you can't work anywhere in the world for 2 years after your employment. Courts won't uphold that. They'll say, no, you can restrict their employment to your direct competitors that would actually siphon off patients. But if that's not going to happen, then forget about it. Unless you're like the celebrity surgeon that, people fly across the world to go see, that's different. But most of you, no offense, are probably not at that point in your careers yet, if you ever will be. That's a very small number of people. So they really look at the geographic scope and they'll want to limit that. They also won't enforce agreements that would restrict your ability to compete for years and years and years afterwards. 2, maybe 3 years is really the outside limit that we see ever being enforced in court. And again, a lot of states, like, my home state of Oregon, they have even more restrictions on these things, to the point that a lot of employers are just saying, no, we're not going to do that. But a lot of employers still do. The more important question, more so than do they hold up in court, is will this employer try to hold it up in court? Because here's the thing, and I've had the fun joy of litigating several non-compete agreements. It's expensive. So even if as an employer, I know that ultimately I will fail to enforce my non-compete, I might do it, or at least try anyway, because I think the other side doesn't want to pay the six figures to some lawyer to try and obtain their freedom out from under that non-compete agreement. And the other thing is sometimes a prospective employer will ask you, are you subject to any non-compete agreements? And if you say yes, they'll want to see it. And then they might run screaming from any job offer because they don't want to get into or invite a non-compete fight. So ironically, what this means in the world of non-competes, it's often way easier to get a job on the other side of the country than on the other side of town. It's,
Yeah.
So again, it's one of those things where when we're entering into an agreement, it's just like we got engaged. I'm looking at my fancy new ring. I'm really excited. And then they come along with this prenup. Well, your restrictive covenant, your non-compete is part of your prenup. And don't be so in love with your new employer that you don't read it, because you need to think about, like, what does this mean if we have a breakup, but I want to stay in town?
Yeah.
The other type of restrictive covenant that we see frequently is what we call a non-solicitation agreement. That means, whether or not I'm free to compete is one thing, but if I'm not free to solicit, I might not be able to ask my fellow physicians to join a new practice with me. I might not be able to go to my PA or my RN and say, hey, come with me to my new practice. That might be part of an agreement where I've said I'm not going to do that for some period of time after my employment ends. It can also apply to patients. Sometimes what we see is an agreement between the physician and the employer on how the physician's departure will be announced to patients, but they might want to restrict you from, just sending out mailings to everybody that you've ever seen for the last year.
Good advice. Yeah, I think there's lots to think about, especially, I think your three kind of points, the geographic scope, what's the limitation there, how long, and any other kind of specific restrictions as it pertains to your specialty. Because if you are moving to a small town and there's a non-compete and you want to leave, you're probably going to have to leave said small town. So I think there's lots of things to think about there. So thank you for that. I don't see any other questions in the chat. So hopefully we covered that well. And now we can kind of move on to the reviewing and negotiating offers. This will be kind of our last section here. But would love to talk about negotiation from your perspective. And, what kinds of things are negotiable? What kinds of things aren't? What should you think about before you try to negotiate? So any opinions that you might have on this, Dennis?
Yeah. So when you're thinking, like, here is the offer I've received, what do I want to do with it? Do I want to negotiate this? Do I want to try and get a better deal? And do I need to see a lawyer? Those are all good questions that you want to ask. And the best thing to do is to sort of stop and assess and think about, what's my game plan going to be? Do I need to get additional concessions from the prospective employer in order to accept this agreement? Or have I basically already accepted it in my heart and I just need to go forward and, sign the thing? How much do I then need to negotiate? Because if it's, I really need them to pay off, my bonus from my prior employer in order to accept this one, then that might be a deal breaker for you and something that you need to be very upfront about, that, hey, this is an issue for me. This is a potential deal breaker. You also need to think about, how much leverage do I have? And by that, I mean, how much can I push without offending the prospective employer or causing them to walk away? Because one thing that at least I and other lawyers that I know will advise our clients is that when somebody's being extremely difficult in the very beginning of the employment relationship, it's not going to get better. So, think about it. This dating analogy that I am using is getting way too much use, but I'm going to stick with it one more time. If you're out on the first date and you notice that your prospective partner is, harassing the waiter and being really picky and sending their food back, and not meeting them and a bunch of stuff like that, you're going to think like, man, if this is the first date, what's marriage going to look like, right? Is this what I'm in for? Well, your employer's looking at this the same way and thinking like, man, they want to nitpick and rewrite this agreement. I can see where this is going to go in the long term. We will pull the plug. So there's a fine line to walk here between standing up for yourself and advocating appropriately and showing that you're not a pushover and asking for things that you need, which is fine, and I encourage it, versus let me see if I can get as much out of this agreement as I can possibly wring out of them, because you're running a big risk that they might say no, and a bigger risk that they might say no thank you at all and end the negotiation. So what I mean by leverage, the more leverage, the more you can do. If you really are like the world's greatest diagnostician, like Dr. House, and you've overcome your addictions, maybe you've got a lot of leverage because people really want that physician at their hospital. If you're a, wet behind the ears resident, sorry, no offense, but you have less leverage. So you need to be realistic with yourself. One trend that I have seen probably in the last 5 years that impacts your ability to negotiate is the push towards pay equity. A lot of states, Oregon included, now have pay equity laws, which mandate how employers pay different people doing the same or similar work, which means they no longer have the ability to just reward the people who ask for more, because they could end up in violation of pay equity laws if they do so. That makes it harder for that employer to negotiate, harder for you as well, because you're not going to be able to get much out of them. So again, if you're a unicorn, there's nobody else that really does what you do and you're unique, you have more leverage because you're not going to cause pay equity problems. If you're a hospitalist and you're going to be one of 50 at the major medical center, you're going to have very little to negotiate on your salary, very little leverage. Some things that are non-salary tend to be way easier to negotiate. That's why, it may be more worth your time to negotiate things like relocation, student loan repayment, or just a plain on just give me the money sign-on bonus. Those the employer will frequently have more flexibility on those. And, you can also look at things like, how much continuing education does the employer provide? Smaller employers might be more flexible on that if you're one of a small number of physicians there. A big health system is going to want that to be the same for everybody. Daniel, you asked, are there any tips on how to negotiate when the employer knows you're going to accept the offer? Yeah, I can give you a couple. One is, if they know that you're going to accept, let's just acknowledge this, right? Because if you go in there and they know you're going to accept, but you're going to pretend like maybe you're not, now they're going to think that like, we can't trust this guy. So you're better off just going like, you love me, I love you, we're going to be happy together. But here's some things that would make me happier. And if you approach it that way, they're going to be far more receptive to that than if they think you're just playing games, because then you're just going to make them mad, and you don't want to make them mad. So I would be upfront about this and say, like, wow, I thank you for the offer. I think this is great. I'll tell you, I'm really inclined to take it. Here are some things that I got to ask about. You know, I just did a negotiation like this when I hired a lawyer a while ago. And I knew he was going to take the offer. He told me, hey, look, I'm going to take the offer, but you know, my wife's going to kill me if I don't ask for some sort of like sign-on bonus. What can you do? And I'm thinking, as the prospective employer, I like this guy. I want to make sure not just that we hire him, I want to make sure that we keep him. I certainly don't want his spouse thinking that like we're a crappy employer and, you know, always encouraging him to look beyond our horizon. So I was like, yeah, let's talk about it. And we negotiated out a sign-on bonus. Everybody happy, because it's worth it for the employer to make you happy. So that's your leverage in that situation, is not just to whether you're going to accept or not, it's whether you're going to accept and be happy and just get this off to a great start.
We're closing in on our last couple of minutes. I am curious, Dennis, if we can, and I think there was another more specific question above this one, but I would like to see if you would be able to answer the idea of, or the question of, when people should actually take their contract to an attorney. I start by offering, this feels like a very frequent question that we get asked on the recruitment side. You know, do you recommend taking it to an attorney? So I think you'll have an interesting perspective here. And then also sometimes when people do take it to an attorney, the idea that they're trying to sort of make it worth their money. So there'll be kind of modifications to verbiage that, can you address that too? I mean, I think that's always so interesting. Yeah. You always say, no, we're not going to change that for you, type of thing. So if you wouldn't mind just taking a crack at in our last, and then I will throw out there for all of you who have questions, we have, please feel free to follow up with us and send your direct questions, and we'll get answers for you since we're running out of time here. But go ahead. And
I see one that I haven't answered, and we're going to come back to it. But to answer the question, do you need to have a lawyer? Absolutely. And my phone number is, everybody write down, really, and this is against my own interests, you don't need to take every contract to an attorney. If you can read it and you can understand it, you don't need a lawyer. Here's a couple, though, caveats to that. If you're contracting with a major health system, I can guarantee you not just one, but multiple lawyers have looked at that agreement. They're going to be very reluctant to negotiate it. So if you can read it and you can understand it, your ability to do anything about it is pretty minimal. And you have to weigh that, like, am I going to get a little peace of mind versus the cost of having a lawyer spend several hours and several thousand of your dollars on it and make that judgment. It's easy for me to say I'm a lawyer and I do this for a living, but I wouldn't advise anybody to just take a standard agreement like that to an attorney. If it's a smaller employer, like a standalone clinic that might not have the resources of a major health system, then I might be more inclined to do so, because I have, one, I've got more leverage to do something about it if there's something fishy in there. And then two, there's more likely to be something fishy in there because it's been through less legal review. So my interest in seeing a lawyer about it really depends on the sophistication of the employer that I'm contracting with. But here's the other thing. This is the agreement that is going to govern your life for as long as you were employed there. If you don't understand it, then pay a lawyer to help you understand it, and it's well worth your money.
Good.
But I am reluctant to tell you in all circumstances to either have a lawyer review it or to pay a lawyer to tell you what to negotiate, because like you just said, I know lawyers that will admit, like, you know, this is a perfectly fine agreement, but I need to justify my fee. Exactly. So I'm going to nitpick $5,000 worth of my time. And it's the person that used to be on the other side of that, I would say, you know, your $5,000 fee is not my problem, buddy. Yeah. So that's what I'm afraid you might get into.
Okay, good. Okay, well, we are now at 1:02. I thought that might happen. So again, for those of you who are still left on here, please do feel free to submit any questions to us and we'll get back to you just in a direct email. Feel free to reach out for any kind of one-on-one advice you might want as well. So that's what we're here for. So if you have questions, our email is on the screen. And otherwise, thank you all so much for taking an hour with us this afternoon. And thanks, Dennis, for joining us.
Thanks, Christy. And thanks to all of you. Thanks for letting us be here today.
Yeah.
John, I saw your question. We'll get you by email.